Officer, please call the case.
Good morning, Mr. President. This is the situation in the Republic of the Philippines, situation number ICC 0121, and for the record, we are in open session.
Good morning again. I am Judge Marc Perrin de Brichambault, presiding this appeal arising from the situation of the Republic of the Philippines. My fellow judges in this appeal are Judge Piotr Hofmansky, Judge Luz del Carmen Ibanez Carranza, Judge Salome Balungi Bossa, and Judge Gocha Lorquipanidze. May I ask the parties and participants to please introduce themselves for the record, starting with a representative of the Philippines, on whose appeal we are deciding today. Please, sir.
Good morning, Your Honor. Good morning to everyone in and around the courtroom. The government of the Republic of the Philippines is represented today by Ambassador Eduardo Melaya, Counsel Jari Osias, Counsel Marisa Kapitangan from the Philippines Embassy here in the Netherlands, and we are also fortunate to have Counsel Sarah Cruz from the Office of the Solicitor General in the Philippines, and I am Sarah Baffadel, External Counsel assisting in this matter. Thank you.
Thank you very much to you. Could I please ask the Office of the Prosecutor to introduce themselves?
Good morning, Your Honor. Appearing for the prosecution this morning, trial lawyer Colin Black to my right, directly behind me, Associate Trial Lawyer Inbal Jalowski, behind me to my right, Associate Trial Lawyer Robin Croft, and I am Senior Trial Lawyer Anton Steinberg. Thank you.
Thank you very much. Could I ask the legal representative for victims, the OPCV, to please introduce themselves?
Merci, Monsieur le Président.
Thank you, Your Honor. The OPCV is represented by Ludovica Vertruccio and myself, Sarah Palais.
PRS is present. Could they please introduce themselves? No? Yes, sorry.
Good morning, Your Honor. For VPRS, on my left, my colleague Alexandra David, and myself, Soraya Brexy.
Thank you very much indeed to all of you. So today the Appeals Chamber will deliver its judgment in the appeal of the Republic of the Philippines against Pretrial Chamber 1's decision of 26th of January 2023, entitled Authorization Pursuant to Article 18.2 of the statute to resume the investigation. I shall refer to it as the impugned decision. This is a non-authoritative summary of the Appeals Chamber written judgment in the appeal. The written judgment, together with a dissenting opinion that is appended to it, will be made available and notified after this hearing. I will now briefly explain the background to this appeal. On the 17th of March 2018, the Philippines announced its withdrawal from the Rome Statute, which became effective from the 17th of March 2019, pursuant to Article 127(1) of the statute. On the 24th of May 2021, the prosecutor requested, pursuant to Article 15(3) of the statute, that the pretrial chamber grant authorization to commence an investigation into the situation in the Philippines. On the 15th of September 2021, the pretrial chamber issued a decision authorizing the commencement of the prosecutor's investigation. On the 18th of November 2021, the prosecutor notified the pretrial chamber that he had received a deferral request from the Philippines pursuant to Article 18.2 of the statute. On the 24th of June 2022, the prosecutor requested the pretrial chamber to authorize the resumption of the investigation into the Philippines situation pursuant to Article 18.2 of the statute. On the 26th of January 2023, the pretrial chamber rendered the impugned decision authorizing the prosecutor to resume the investigation into the Philippines situation pursuant to Article 18.2 of the statute. On the 13th of March 2023, the Philippines filed its appeal brief, raising the following 4 grounds of appeal. First, the Philippines alleges that the pretrial chamber erred in finding that the court could exercise its jurisdiction on the basis that the Philippines was a state party at the time of the alleged crimes, despite its subsequent withdrawal from the statute. Second, the Philippines alleges that the pretrial chamber erred in reversing the prosecutor's burden of proof in the context of Article 18 proceedings. Third, the Philippines alleges that the pretrial chamber committed an error of law in its application of the legal standard applicable to a case, overstating the degree of overlap required in the Article 18 context, which invalidated the entire admissibility assessment. The Philippines also alleges a number of errors in the pretrial chamber's findings on specific domestic proceedings and on the degree of overlap with the court's investigation. Fourth, the Philippines alleges that the pretrial chamber's finding that it was not satisfied that the Philippines is making a real or genuine effort to carry out the investigations and prosecutions is not based on any actual assessment, and that the pretrial chamber failed to consider whether the situation is of sufficient gravity. The Philippines seeks the reversal of the impugned decision. Before I address the merits of the appeal, I would like to state that it is rejected by the appeals chamber by majority, and that the impugned decision is therefore confirmed. I will now address the merits of the appeal and the appeals chamber's findings. Under the first ground of appeal, the Philippines alleges that the pretrial chamber erred in finding that the court could exercise its jurisdiction despite the Philippines' withdrawal from the statute. The Philippines also argues that it is entitled to raise this issue in its appeal, as the impugned decision contains a positive finding of jurisdiction based on the Philippines' status as a state party to the Rome Statute at the time of the alleged crimes. The appeal chamber by majority, I and Judge Orquipanidze dissenting, finds that the Philippines sets out the alleged errors in a manner that renders unclear both the precise nature of its challenge as well as the legal basis pursuant to which the challenge is made. The appeal chamber by majority observes that the impugned decision does not constitute a decision with respect to jurisdiction within the meaning of Article 82(1)(a) of the statute. While the pretrial chamber addressed the issue of jurisdiction in general terms, the impugned decision is not a decision on jurisdiction. Contrary to the Philippines' assertions, the findings of the pretrial chamber, in particular those concerning the court's jurisdiction over the present situation, and the effect of the Philippines' withdrawal on the court's jurisdiction, are not a positive finding of jurisdiction that is inextricably linked to its admissibility ruling. Rather, the pretrial chamber simply recalled and reaffirmed its previous findings on jurisdiction made in its decision authorizing the investigation under Article 15 of the statute. Furthermore, the issue of the impact of the Philippines' withdrawal from the statute on the court's jurisdiction was neither properly raised nor adequately ventilated before the pretrial chamber. The appeal chamber by majority, Judge Orquipanidze and myself dissenting, therefore considers that the appeal chamber cannot entertain the Philippines' appeal at this point. As a result, the appeal chamber by majority, Judge Orquipanidze and myself dissenting, dismisses the first ground of the appeal, of the Philippines' appeal. As a result of the dissenting opinion of Judge Orkipanidze and myself with respect to the first ground of appeal, the following grounds of appeal are only considered by the majority of the appeals chamber. Under the second ground of appeal, the Philippine alleges that the pretrial chamber erred that in Article 18 proceedings, the prosecutor, as moving party, bears the burden of proof. It is because, in its view, the state is not the party seeking to change the status quo. Rather, the prosecutor is seeking a preliminary ruling regarding admissibility to end his continued deferral after having received a deferral request from his state. The majority recalls that Article 18.2 of the statute provides that a state may inform the court that it is investigating or has investigating the relevant persons and request a deferral. The majority further recalls that Rule 53 of the rules requires the state seeking a deferral to provide information concerning its investigation. The majority notes that by informing the court that it is investigating or has investigated and requesting deferral, the state concerned is alleging a fact. The majority is of the view that the court's legal text placed the burden of proof in Article 18 proceedings on the party which seeks to establish the existence of a fact. It is thus incumbent upon the state to establish the facts supporting the assertion. Recalling Rule 54.1 of the rules, the majority notes that when the prosecutor seizes a pretrial chamber with an application for a ruling under Article 18.2 of the statute, the pretrial chamber, in its determination of the prosecutor's application, relies on the information which the state initially provided to the prosecutor. As a result, the burden of providing information relevant to the pretrial chamber's determination under Article 18.2 remains on the state seeking deferral, and the prosecutor's subsequent duty to communicate to the pretrial chamber the information initially provided by the states in support of its deferral request does not affect the allocation of the burden of the proof. For the foregoing reasons, the majority finds that the Philippines has failed to demonstrate that the pretrial chamber erred in placing the onus on the Philippines to show that investigations or prosecutions are taking place or have taken place. Therefore, the majority rejects the second ground of appeal. Under the third ground of appeal, the Philippines alleges that the pretrial chamber erred in applying the same person, same conduct test and the high standard of assessment of the degree of mirroring with the prosecutor's investigations, both tests being, in its view, applicable to cases rather than to situations. Philippines provide a number of examples of domestic proceedings which it submits were erroneously assessed. The majority recalls the jurisprudence of the appeals chamber that any investigation, irrespective of its stage, has certain defining parameters. The majority is of the view that for the purpose of admissibility challenges under Article 18 of the statute, a state is required to demonstrate an advancing process of domestic investigations and prosecutions of the same groups or categories of individuals in relation to the relevant criminality, including the patterns and forms of criminality within a situation. The domestic criminal proceedings must sufficiently mirror the scope of the prosecutor's intended investigation. The appeal chamber observes that a pretrial chamber's assessment in this context is a largely fact-driven inquiry. The majority notes that in the present situation, the general parameters of the situation were defined by the pretrial chamber's Article 15 decision and by the prosecutor's notification to the Philippines under Article 18.1 of the statute, and that those parameters were sufficiently specific to enable the Philippines to provide information in relation to its domestic investigations and prosecutions under Article 18.1 of the statute and demonstrate the degree of mirroring. The pretrial chamber stated that it considered whether the domestic investigations and prosecutions of the Philippines cover the same individuals and substantially the same conduct as the investigations before the court. The majority notes that the pretrial chamber, however, acknowledge that its assessment must be carried out in the context of a specific situation and taking into account the different types of investigations. Furthermore, in its application of the test, the pretrial chamber examined whether the Philippines showed, first, that it is indeed investigating and prosecuting the same groups or categories of individuals in relations to relevant criminality within the scope of the situation, i.e. crimes related to the war on drugs campaign. Second, that it has undertaken tangible, concrete, progressive investigative steps in its investigations and proceedings. And third, that its domestic investigations and prosecutions sufficiently In light of the foregoing, the majority considers that in its assessment of complementarity in the context of Article 18.2 of the statute, the pretrial chamber correctly assessed whether there exists an advancing process of domestic investigations or prosecution of the same groups or categories of individuals in relation to relevant criminality within the situation which sufficiently mirror that of the prosecutor, taking into account the stage of the situation as well as the specific circumstances and parameters of the Philippines situation. Therefore, the majority finds that the pretrial chamber did not err in law. The Philippines alleges a number of errors in the pretrial chamber's findings on specific domestic proceedings and on the degree of overlap with the court's investigation. With respect to the pretrial chamber's assessment and rejections of information submitted to substantiate the Philippines investigation, the Philippines alleges that the pretrial chamber erroneously imposed a high threshold developed in the Article 19 context. For the reasons set out in detail in the judgment, the majority finds that the Philippines has failed to demonstrate any errors of the pretrial chamber in the impugned decision. As regards the pretrial chamber's assessment concerning the contours of the investigation, the Philippines alleges that the pretrial chamber imposed a degree of mirroring with the prosecution investigations which cannot reasonably exist at the Article 18 stage, whereby the contours of the prosecution's investigations concerning a specific case are undefined and unclear. For the reasons set out in detail in the judgment, the majority find that by failing to show instances in which the pretrial chamber allegedly applied the wrong threshold or standard, the Philippines has failed to demonstrate the alleged legal error. Having rejected the Philippines' arguments regarding the application of the alleged erroneous admissibility test and the examples of alleged erroneously assessed domestic proceedings, the majority rejects the third ground of appeal. Under the fourth ground of appeals, the Philippines alleges that the pretrial chamber's finding that, in its view, the Philippines is not making a real or genuine effort to carry out investigations and prosecutions is not based on any actual assessment. The majority does not agree that the pretrial chamber's finding that no real or genuine effort was made was a finding on the Philippines' willingness and ability to carry out investigations. This finding of the pretrial chamber should be viewed in light of the two-step approach that the pretrial chamber applied, which requires it to assess the willingness and ability of the domestic authorities to genuinely carry out an investigation or prosecution only if it first finds that there were ongoing or that there had been investigations or prosecutions. In the present situation, the pretrial chamber concluded that both questions were answered by the negative. Consequently, the question of unwillingness or inability did not arise. The Philippines also submits that the pretrial chamber erred in law by declining to consider the potential gravity of potential cases within the Philippines situation. The majority notes, however, that the pretrial chamber did consider the Philippines' arguments on gravity and limited its findings to the arguments which the Philippines actually raised. The majority finds no error in the pretrial chamber's approach to only address those issues of gravity that the Philippines had actually raised before it. Therefore, the majority dismisses the Philippines' arguments regarding gravity. The majority rejects the fourth ground of appeal in its entirety. I am now going to summarize the dissenting opinion of Judge Lord Kipanidze and myself, and I intend to do it in the French, so maybe you will need to get some earphones. Dans le jugement d'aujourd'hui,
In today's judgment, the appeals chamber, by majority, dismissed the first ground of appeal raised by the Philippines in its appeal brief. From the appeal chamber's point of view, given that, first of all, the impugned decision is not a decision on jurisdiction, and secondly, the issue of the effect of the Philippines' withdrawal from the statute on the jurisdiction of the court was neither properly raised nor adequately ventilated before the pretrial chamber, nor was the issue adequately raised upon appeal. The appeals chamber cannot consider the Philippines' appeal on this point. Judge Lord Kipanidze and I respectfully disagree with the majority. We are of the view that the first ground of appeal is admissible, and we would have considered it on the merits, and we would have allowed it. We are of the view that the appeals chamber has been properly seized of the exception of the lack of jurisdiction raised by the Philippines, given that first of all, the impugned decision does contain a finding on jurisdiction, and secondly, the Philippines has correctly identified an error in this finding. First of all, in our view, the issue of jurisdiction raised in the appeal brief is a practical issue in the context of the impugned decision. In accordance with the invitation by the pretrial chamber, the Philippines filed its observations on the prosecutor's Article 18 application, raising, inter alia, issues relating to the jurisdiction of the court. In particular, the Philippines submitted arguments concerning the court's alleged lack of material jurisdiction, insufficient gravity of the constituent crimes, and a more general argument on state sovereignty. As a preliminary matter, the pretrial chamber examined several general challenges of the court's jurisdiction raised by the Philippines in its observations and made a specific finding on the effects of the Philippines' withdrawal on the jurisdiction of the court, although the arguments of the Philippines did not specifically relate to the effect of its withdrawal from the statute. Contrary to the conclusion of the majority, we are of the view that the impugned decision did make a finding on jurisdiction, and that this finding is an integral part of the decision and constitutes the foundation thereof. As such, we would have addressed the merits of the Philippines' arguments challenging the court's jurisdiction. Furthermore, we are of the view that the fundamental issue of the court's jurisdiction should be resolved as soon as possible. When an aspect of the court's jurisdiction is duly challenged, the court must ensure at the first opportunity that it does indeed have jurisdiction. This is particularly so in the case at hand, in which the Philippines concretely challenged the jurisdiction of the court subsequent to its withdrawal from the statute. In our opinion, this approach is consistent with the recent judgment by the Appeals Chamber in the situation in the Islamic Republic of Afghanistan. In that judgment, the Appeals Chamber reviewed the scope of the jurisdiction as part of an appeal arising from proceedings under Article 18. Now, although the pretrial chamber may have already made similar findings on jurisdiction in the Article 15 decision, which are referred to in the impugned decision, Article 15 of the statute does not provide for the participation of the state concerned in the relevant proceedings. Consequently, the Philippines was neither a party to nor a participant in the Article 15 proceedings in this situation. It is only as part of the proceedings under Article 18.2 that the Philippines had the opportunity to raise issues concerning the jurisdiction of the court. Although these arguments do not bear expressly upon the Philippines' withdrawal from the state, the pretrial chamber did rule on this matter in the impugned decision. As such, we are of the view that the Philippines' challenge of the jurisdiction of the court was proper, and that the appeals chamber should have examined the challenge on its merits. Secondly, the Philippines argues that the pretrial chamber erred in law by concluding that the court could exercise its jurisdiction on the basis of the fact that the Philippines was a state party at the time of the alleged crimes, and that the obligations under the Rome Statute remain applicable, notwithstanding the Philippines' withdrawal from the statute.
An overall reading of Articles 12, 13, 15, 18.1 and 127 of the statute leads us to consider that there's a distinction between the existence of jurisdiction and the court's ability to exercise that jurisdiction, and that the conditions for the exercise of jurisdiction, as they are set out in Article 12 of the statute, must exist at the time when jurisdiction is triggered under Article 13 of the statute. Article 12(2) of the statute, read in conjunction with Articles 13c and 15 of the statute, provides that where the prosecutor has initiated a proprio motu investigation in respect of a crime within the jurisdiction of the court, in accordance with Article 15 of the statute, the court may exercise its jurisdiction if one or more states of the states concerned are parties to this statute or have accepted the jurisdiction of the court in accordance with Article 12.3 of the statute. In our view, the wording of this provision indicates that the appropriate time for determining whether the preconditions of Article 12 of the statute are met is when the court intends to exercise its jurisdiction, and not when the crimes are alleged to have been committed. In other words, the preconditions for the exercise of the court's jurisdiction must exist at the time when jurisdiction is triggered in accordance with Article 13 of the statute, which in the scenario provided for in Article 13c of the statute certainly occurs when the pre-trial chamber authorises the investigation in accordance with Article 15.4 of the statute. Bearing in mind that the Rome Statute is both an international treaty and an international criminal code, two concomitant interests can be discerned when a state withdraws from the statute. Article 127 of the statute guarantees states parties the right to withdraw from the statute. In this respect, we consider that it is a fundamental right of states to decide whether or not they wish to be bound by a treaty. We are also aware of the statute's objective of ending impunity. There is an obvious risk of conflict between these two competing considerations. Indeed, there's a risk that a state will use its right to opt out of the statute to shield certain individuals from prosecution by the court. We believe that the statute strikes a fair balance between these competing considerations and provides for a procedure that enables the court to prevent any abuse of a state's right to withdraw. Article 1271 of the statute provides that withdrawal shall take effect 1 year after the date of receipt of the notification. Therefore, the prosecutor must make every effort to trigger the court's jurisdiction in a manner that does not prejudice a state's right to withdraw from the statute. In our view, 1 year is sufficient for the prosecutor to conduct his preliminary examination and request a pretrial chamber to authorise the commencement of the investigation and for the pretrial chamber to rule on that request. The statute thus gives the court the opportunity to assert its jurisdiction. However, it also respects the right of states to withdraw from the statute and therefore provides for limitations on this power of the court. Without these limitations, the court's jurisdiction would expand to an extent that would defy the assurances and guarantees given to states in the statute. This could have a negative impact on the court system as a whole. In the present case, as the prosecutor did not trigger the court's jurisdiction before the withdrawal took effect, the Philippines reaffirmed what it considered to be its primary jurisdiction. When the former prosecutor submitted his request for authorization for an investigation on the 24th of May 2021, the Philippines was no longer a party to the statute, its withdrawal having taken effect on the 17th of March 2019. And furthermore, it should be noted that the pre-trial chamber issued its decision on Article 15.4, authorising the investigation of the prosecutor in September 2021, so more than 2 years after the fact of the withdrawal of the Philippines. Where it concerns the interpretation of Article 1272 of the statute, we consider that the prosecutor's preliminary examinations are not a matter under consideration by the court within the meaning of Article 1272 of the statute, and that a situation is not under consideration by the court until the pre-trial chamber authorises the opening of an investigation into that situation. This is largely due to the informal nature of preliminary examinations, which do not carry sufficient weight to engage the jurisdiction of the court in the absence of formal authorization by a pre-trial chamber to open an investigation in accordance with Article 15 of the statute. We consider that the last sentence of Article 1272 of the statute cannot be invoked to extend the prosecutor's power to submit a request under Article 15.3 beyond the time when the withdrawal has become effective. Crucially, the interpretation of Article 1272 of the statute, as advocated by the prosecutor, cannot be reconciled with the principles of the Vienna Convention on the Law of Treaties and with the intention of the drafters of the statute, as this interpretation would render Article 127 meaningless by allowing the court's jurisdiction to be triggered indefinitely. In our view, Article 127 of the statute is contained in the final clauses, Chapter 13 of the statute. The provisions contained in that part cannot alter the jurisdictional regime carefully elaborated in Chapter 2 of the statute. For these reasons, Judge Lord Kipanitsa and I consider that the pre-trial chamber erred in law in concluding that the court has jurisdiction over the situation in the Philippines despite the withdrawal of the state. Accordingly, we would have upheld the Philippines' first ground of appeal and found that the court cannot exercise its jurisdiction in the situation in the Philippines. Consequently, we would have held that the other grounds of appeal were without object. We would have also asked the pre-trial chamber to withdraw its authorization for the prosecutor's investigation and to terminate all proceedings in this situation.
And for the reasons stated more fully in the written judgment, the appeals chamber by majority, Judge Lord Kipanidze and myself dissenting, rejects the appeal and confirms the impugned decision. This brings an end of the summary of the appeals chamber judgment. The reading of this judgment takes place on the 25th anniversary of the signing of the Rome Statute. It shows the continuity of purpose in implementing this ambitious endeavor and in affirming the values of justice by all those who have contributed to it. I would like to thank them. I would like to thank the court reporters, interpreters, and other registry staff for their valuable assistance today in holding this hearing. The hearing is adjourned.
All rise. We will.
Tuloy ang investigasyon ng International Criminal Court sa war on drugs noong termino ni dating Presidente Rodrigo Duterte na nagdulot ng libo-libong pagkamatay ng mga Pilipino. Ito ay matapos umapila ang gobyerno sa pamumuno ni Presidente Ferdinand Bongbong Marcos Jr. matapos buksan muli ng ICC ang kanilang investigasyon sa war on drugs. Ayon sa gobyerno, opisyal na kumalas ang Pinas sa ICC noong 2019. Kaya dapat ay wala na sa jurisdiksyon ng korte ang bansa. Pero kinukonsider pa ring valid ang investigasyon dahil naganap ang drug war noong miyembro pa ang Pilipinas ng Rome Statute. Ang Rome Statute ay ang kasunduan na nagtatag ng International Criminal Court. Tuloy-tuloy sana ang investigasyon ng ICC sa war on drugs, pero pansamantala ito itinigil noong November 2021 nang sinabi ni Duterte na magkakaroon ang gobyerno ng sariling investigasyon. Pero hindi ito naging sapat para kay ICC Prosecutor Karim Khan, kaya umapila siya na maituloy ang kanyang investigasyon. Pumayag ang ICC na ituloy ni Khan ang kanyang investigasyon nitong January 2023. Hindi na maaaring umapila ang Pinas sa ICC matapos ang desisyon na inihain nito. Tuloy ang investigasyon ng International Criminal Court sa War on Drugs noong termino ni dating Presidente Rodrigo Duterte na nagdulot ng libu-libong pagkamatay ng mga Pilipino. Ito ay matapos umapila ang gobyerno sa pamumuno ni Presidente Ferdinand Bongbong Marcos Jr. matapos buksan muli ng ICC ang kanilang investigasyon sa War on Drugs. Ayon sa gobyerno, opisyal na kumalas ang Pinas sa ICC noong 2019. Kaya dapat ay wala na sa jurisdiksyon ng korte ang bansa. Pero kinukonsider pa rin valid ang investigasyon dahil naganap ang drug war noong miyembro pa ang Pilipinas ng Rome Statute. Ang Rome Statute ay ang kasunduan na nagtatag ng International Criminal Court. Tuloy-tuloy sana ang investigasyon ng ICC sa War on Drugs, pero pansamantala ito itinigil noong November 2021 nang sinabi ni Duterte na magkakaroon ang gobyerno ng sariling investigasyon. Pero hindi ito naging sapat para kay ICC Prosecutor Karim Khan, kaya umapila siya na maituloy ang kanyang investigasyon. Pumayag ang ICC na ituloy ni Khan ang kanyang investigasyon nitong January 2023. Hindi na maaaring umapila ang Pinas sa ICC matapos ang desisyon na inihain nito.